Good afternoon, members. This is the Jackson County League of Women Voters monthly meeting, and I'm Sandy Latecki, president, and I'd like to welcome everyone, including our guest speaker, Michele Thorne, who is an attorney in the Chicago area. She is a league member, and she has been active in many different areas, and this last year, she drafted an resolution that passed both chambers of the Illinois legislature. Michele will speak to us on an update about the amendment. Michele, go ahead.
Thank you for the introduction, Sandy. Thank you to the League and the library for hosting this talk. I love to talk about the ERA. I do hope that I can also hear from all of you because I'm interested in hearing what you have to say and what your questions are. And I think there's a Q&A. So I'm going to look down from time to time to make sure that I am staying on track. And I've urged Sandy to, or anyone else to give me a reminder so we have time for Q&A. I am going to screen share now. Let's see. Okay, share screen. Share. And slideshow. Okay, hopefully everyone can see my slides. If not, someone let me know.
Looks good, Michele.
Okay, good. I am really grateful to be talking with all of you today. I am so excited to talk about the Equal Rights Amendment. And I love the League of Women Voters and libraries for that matter. So this is a great gig for me. And as I say, I hope to be able to hear from you through the Q&A or however we can facilitate that because I'm interested in learning from you. I decided the way to frame my talk is as a gift. So if you only take one thing from my talk this afternoon, I hope it is that the Equal Rights Amendment is a gift. I showed you a gift box. We just came from the gift giving season of many holidays. And as I say, I'm characterizing the Equal Rights Amendment as a gift because to me it is. So what is the ERA? What's in the box as I've written on this slide? The ERA has 3 sections, and I thought it made sense for us to go through that because if we're talking about a law, you should know what the law is and why it matters. So the first section of the ERA is the 24 words with which you're probably familiar. And probably some of you have been advocating for the ERA for a long time. I realize that this might be redundant for some of you, but I'm going to just go over basics because it's also good for me in framing my talk. The first section of the ERA says, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. What does that mean? Well, let's take it apart. And as a lawyer, I love to do this. I love to take language apart. My background is as somebody who has analyzed agreements, drafted agreements, negotiated agreements, interpreted them. So this is very natural to me, and this is something I love to do. What is the word equality? Let's start right there. 1 + 4 = 2 + 3. 1 + 4 is not the same as 2 + 3, but they are equal. Very basic, but it's an important point. A lot of people think that the ERA mandates that everything has to be the same for everybody. And that's not true. That's not a correct reading, in my opinion, of the ERA. It's an equivalence. It means that things have to be equivalent, but not the same. What are rights under the law? That could be a right that I have to do something, or you have to do something, a right for you not to do something, maybe a right to get something from the government or a right to keep the government away. Those are all examples of types of legal rights. Why does it say shall not be denied or abridged? That's kind of weird wording. It's what you're not supposed to be doing when you write. It's a negative, so it makes it harder to understand. Why is it written in the negative? Because our United States Constitution is considered a negative rights constitution. When the founders drafted the Constitution, and they set up this new in 1787, three-branched government, they were a little scared because they just a couple decades before had gotten rid of the tyranny of England, and they didn't want another tyrant in the form of a national government. In 1787, when they wrote this Constitution, the states were pretty much sovereigns, joined together for mutual benefit, kind of like the early EU. But with this new Constitution, it became different, where they shared some powers with the national government. The idea is that it's a negative rights constitution because the founders and drafters of amendments wanted to keep the government out of their business. They wanted to make sure the government was limited and didn't violate their rights. That's why we have a negative rights constitution rather than one that spells out the rights that we do have. So that's why it says shall not be denied or abridged. It's a prohibition on the government doing something. And I talk about the government because the next few words are by the United States or by any state. That's all government bodies in the US. The national government, the state government, and state government includes local government. So this is a prohibition against all of those governmental bodies and all branches of them, agencies, executive, judiciary, legislature. It's prohibiting them from violating rights. And then the last four words are on account of sex. What does that mean? Well, under recent US Supreme Court case law, there was a case called Bostock v. Clayton County, I think from 2020, that for purposes of a federal statute called Title VII, having to do with employment law and fairness in employment, that case interpreted the word sex to include sexual orientation and gender identity. So it's possible that the ERA would be interpreted more expansively as well. And I also like to mention, since this is the heart of the ERA, people call the ERA the Women's Rights Amendment. Do you see the word woman in there? You do not. Why? Because this amendment works for everybody. It's for everybody. It's for men as well. But it's not wrong to call it a women's rights amendment because historically, women have been the largest group that have faced this form of discrimination. And another thing I like to mention about Section 1 is that it's really a codification of the Golden Rule. The Golden Rule is a most important tenet in every major religion around the world and most secular societies. The idea that you treat others as you would be treated. That's essentially what the ERA is saying. It's a rule of fairness. And that's why it's so easy to support the ERA, because people who support it think that there should be fair rules. People who vote against it are afraid that the rules will be fair, and they don't want that. That's my take on it. Section 2 gives Congress the ability to enforce the ERA, to pass laws. And this is important because Congress only has as much authority as the Constitution gives it. Our Constitution, US Constitution, is our supreme law. And if any powers that our national government, any branch of our national government has, have to have an anchor in the Constitution. So this section clearly says, Congress, you do have authority to pass laws. And that whole concept of what is Congress's authority will come into play later in our discussion. But that's why it's in Section 2. It's saying, Congress, you do have authority to pass laws based on this amendment. And Section 3 doesn't have a lot of meaning today in terms of its effect. It has a delayed effectiveness. So once the amendment is fully ratified and becomes part of the Constitution, it's not legally effective for 2 years later. That's the idea. It's a time frame. In that way, it is something that's relevant. And you see, this is the text of the amendment, Section 1, Section 2, Section 3. If you want something to have the force of law with it as part of the Constitution, you have to put it in the text. It's like any other contract. If you want to do something legally, I'm sure you've worked on real estate transactions, other transactions, you have to make sure your most important terms are in writing that both parties sign. And that's essentially what this amendment is. It's amending a contract, that we have a social contract called the US Constitution. So, I'm getting into the weeds a little bit, but this is important for our later discussion. This Section 3 was important when the amendment was first proposed. The first version of the amendment was proposed in Congress in 1923, so 100 years ago, by 2 Republicans from Kansas. And at that time, and then again in the 70s, when it finally passed out of Congress, there were so many laws at the national level and the state level that would have had to be changed. The idea was give a 2-year lag time for folks to change laws. Why have the ERA? What's important about it? Well, in 1923, as I mentioned, that's when Alice Paul and others worked on the ERA and first proposed it through the National Women's Party. A real focus was the legal concept called coverture. And coverture is something that the British and the French kind of exported to our country. Those colonists imported this legal concept. And what it is a common law concept, applies specifically to married women, but it really in practice kind of applied to all women. The idea was that women were not actors on their own. They were covered by their fathers when they were in their family home, and then legally by their husbands, because most women married in the olden days. And once a woman was married, she was not really a legal person. She could not act on her own. Her husband was her legal representative. The idea was that the woman became part of the man, and that he then was her voice. It's a really important concept, and it was still an important concept, as I say, in 1923, because a lot of rights of women came through their husband or just were restricted because women were not recognized fully as people having the same rights as men. And we can talk more about that in the Q&A. I could talk more about it. It's a fascinating topic. But one thing to mention is that this concept of coverture still permeates our laws. And to me, it's one of the most important reasons that we need the ERA. And in fact, in a case that came out from the Supreme Court last year, the Dobbs case, you will see that concepts of coverture as foundation for that women are kind of, gendered, their citizenship is gendered. It's different from men's citizenship. Again, we can talk about that later. I'm watching my timer, and I want to hear from you, but I'd love to talk more about that. And I would say that's still part of our common law. In 1972, why was the ERA important? In 72, we'll talk later, is when the ERA came out of Congress. There were, some of you may have lived through this. It wasn't until the 70s that women could apply to get their own credit cards. Their husbands had to apply for them. Women's education was often restricted. I was just talking with my own mother about how she had to be in a woman-only dorm where the hours were limited, and my dad said that they had no hours in his dorm at a public university. But women's sports, there were all kinds of things where women were not treated equivalently with men. Employment, there's a long history of issues with sex discrimination in employment. We know about sexual harassment that's continuing and assault. Domestic violence continues to be a really strong reason for the ERA to be passed. And women sometimes become pregnant during their fertile years, and pregnant women sometimes are not treated as other citizens are treated. And of course, in the 70s, pregnant women were fired from their jobs. My mother, again, referring to her, was a teacher, and she had to hide the fact that she was pregnant or she would have been fired. Those are examples. Some of this continues. Some of these issues continue today. And then today, the Me Too movement focused really on harassment and assault, certainly reproductive rights, and to the extent that that term sex is interpreted more broadly, discrimination against people in the LGBTQ plus community. And in the future, we might have some of all those same issues. And to some extent today, we have the AI issue, artificial intelligence. I was just reading an article in the New York Times where someone had asked, what gifts would you suggest for boys and girls? And the focus was, and the response from, I don't know if it was ChatGPT, was dolls are great for girls and science kits are great for boys. This kind of goes back to, garbage in, garbage out. And there's a lot of discrimination already embedded in our systems and by the people who craft our technology or the information they rely on. And there's a concern that to the extent that computers are making decisions that affect people, that they will have these ingrained biases. So that's a real concern, I know, in among people who care about human rights generally. So I talked about what's in the box. I talked about how you can use what's in the box. And now what's the instruction manual? And again, it's a little legalistic because we're talking about the law. We're talking about the Constitution. When you have a right under the Constitution and you claim that that right has been violated, then when a court reviews whether the government violated that right, they engage in something called judicial review. And that's how seriously they will review that your right was violated. And the highest level of review is called strict scrutiny. And by getting the ERA into the Constitution, what it effectively does is it raises the subject or the class of sex to a suspect classification. Right now, gender discrimination is usually looked at under the 14th Amendment. And because the 14th Amendment was geared more toward race discrimination, discrimination on the basis of nationality, the court has interpreted the 14th Amendment to require a lower level of review when there's sex discrimination. In fact, there is a famous quote by Antonin Scalia that says, that the Constitution doesn't prohibit sex discrimination. And if you want the Constitution to prohibit sex discrimination, then amend the Constitution, put it in the Constitution. And that's what the ERA does. It raises the importance of sex discrimination in terms of how the court will view it. And it also shifts the balance in terms of if someone complains about it, the burden of proof is shifted more toward the body, this would be the government, to prove that they had a justification for discriminating. And that justification is called the compelling government interest. So it's a really high standard for the government to have a rationale that they have discriminated. And then the other prong under strict scrutiny is that whatever way in which the government has discriminated, and I would say differentiated, but as I say, you can have some differences, but if it's not equivalent, if they're not treating sexes equivalently, the government has to minimize its impact of discriminating. So that's this narrowly tailored idea, that they have to show it's necessary, that the breadth is limited, and that that third parties, the harm to them is limited. So this is kind of legal mumbo jumbo, but it is legally really significant to the argument that we need the ERA. And the other thing that's great about this is that if you ask questions, if we have a discussion, after my presentation about tricky issues of today, how would the ERA be interpreted? I might say, here's how I would interpret it. I'm not in the federal judiciary or a state Supreme Court to the extent they handle the US Constitution. So I don't know definitively how they would interpret it, but they would have to have a good argument of fairness. Fairness kind of permeates all of this. But I would also say that the advantage of the tricky issues, and we're always going to have tricky issues where people have a different idea of fairness. The advantage of having it in our highest law is that the judiciary has to follow this instruction manual in making its decision. And that's good. It's a tool. So it's not just out there what the justices think. This is the metric by which they would make a decision. And that's a good thing for them to have a metric. So, and again, we can talk about that more later. And then I just want to say, and this is kind of an overall theme of mine, is that the gift is valuable. Poll after poll shows that across the sexes, across politics and economics, the vast majority of Americans support the ERA. Again, legal, but I want you to know this because of what I'm going to tell you after this. How is the gift wrapped? The way I think of it is this two-step process is that one step is sort of the wrapping and one is the bow. The Constitution itself, like any good ongoing agreement, specifies how it can be amended. It's in Article 5 of the Constitution, and Article 5 is just one paragraph long. In fact, it's really just one sentence, compound sentence, that lays out a two-step process. The first thing to amend the Constitution is that there has to be a proposal. Generally, that's done by Congress, 2/3 of each house of Congress. That can also be done through a national constitutional convention initiated by 2/3 of the states. We have never had that yet for a constitutional amendment. Some people are kind of wary of that. But that's how the 1787 Constitution, the Constitution that we have, that's how it was drafted. The 13 then states all sent representatives to Philadelphia in the summer of 1787, and behind closed doors, they came up with this one-size-fits-all Constitution. So we have had a National Constitutional Convention before, and it was to draft our original Constitution. So Congress just proposes, and it makes sense to have Congress propose amendments because Congress is a national representative body. It represents the people in the states, and it's organized and it regularly meets. So that's the obvious way for amendments to be proposed. Otherwise, you'd have amendments percolating up from the states, and that would be very hard to manage, as probably would be a National Constitutional Convention. But the bar is pretty high. It has to be 2/3 of each house of Congress within the same congressional term. And then the second step is called ratification. And that's a term that a lot of people use, and they don't use it correctly. They use it just to mean kind of approval or acceptance, but it's a technical legal term. And it's actually from agency law, where you have a principal and an agent. The states are the principal. They're the most important party under the amending provision of the Constitution. Because if the states didn't have confidence that they'd be able to amend that original one-size-fits-all Constitution, they wouldn't have ratified the Constitution itself. They wouldn't have approved it. We wouldn't have the country as we know it. Even George Washington, in his farewell address, made that point, that the amending provision, without that, we wouldn't have a Constitution. I think it's one of the most important provisions of our Constitution, and it's the states that ratify. That is the second and final step of the amending process. And they're the final decision makers. Congress just proposes. And again, when people talk about the amending process, they kind of flip it on its head and make it sound like Congress is most important. And I disagree. The states are the final decision makers. And once they ratify, they're authorizing and adopting that proposal, and you can't undo it. So ratification's done by the states, and it's almost always done by the legislatures, which is similar to the proposal coming through Congress. The state legislatures already are organized, and they meet regularly, and they represent the people in the state. And it's a lot easier to have the legislatures make that decision than to have separate state constitutional conventions organized. We did have state constitutional conventions once in our history for an amendment, and that was for the 21st Amendment, which repealed prohibition. People were so eager to get that done quickly that it was done through constitutional conventions. So what is our history with the ERA? How was that gift wrapped? And again, I'd call the proposal sort of the wrapping and the ratification the ribbon. Overwhelmingly in 1972, the House and the Senate, look at those numbers, it's like 90% plus, voted to propose the Equal Rights Amendment. But it wasn't until pretty recently, January 27th, 2020, that the ERA became fully ratified. In the previous slide, I said 3/4 of the states, it's a really high bar, have to ratify an amendment. So with 50 states, that's 38. Illinois was the 37th, which is kind of shocking because, as we'll discuss later, Illinois is really a leader of the ERA today. Thanks in part to the League of Women Voters of Illinois, what all of you do, and you should know that as well. So it took 48 years for the ERA to be ratified, because once Congress proposes an amendment, they voted on it, 2/3 in each house, it's sent out to the states, and then the states decide whether they want to ratify. The way I'm framing it is the gift has been presented. So once the states ratify, well, actually, once Congress proposes it, the official resolution that was used in Congress to propose an amendment, that's sent to the archives. So that's on file. Step one, we know that's done. Step two, 3/4 of the states. How does that work? Each time a state legislature ratifies an amendment, they send a authenticated, certified document showing that they ratified, and they send that to the archives. And the National Archivist makes a check mark, and once those check marks get to 38, the job of the archivist is to certify that the constitutional requirements have been met and to publish the amendment. In fact, it's 1 USC 106B, that's our US code, our federal law, says that the National Archivist has to do that certification and publication forthwith. That's a time pressure. So upon receiving all those ratifications, that archivist is supposed to do this. Well, the gift remains unopened. And you maybe know this, because that might be why I'm talking to you today. The ERA has not been published. It is not yet officially recognized as our 28th Amendment. Why not? There are two arguments against recognizing the ERA as our 28th Amendment. The first argument is that about half a dozen states over this 48-year period have voted to rescind their ratifications. But here's the catch. Technically, once a ratification is made, you can't undo it. There are no takebacks. We know that from our own US Constitution. When New York was considering whether they wanted to ratify our 1787 Constitution, our Constitution, before it was amended, it was Alexander Hamilton who in, I think it was 1788, New York still hadn't signed on, wrote a letter to James Madison, who's considered the father of the Constitution because he was so involved with drafting it. And Alexander Hamilton wrote to James Madison saying, you know, New York is ready to ratify the Constitution. We really want to be part of this United States, this new version of the United States. But we're a little concerned about a couple of things, including that it doesn't have a Bill of Rights. And what we would like to do is we'd like to have the New York delegation ratify the Constitution, but conditionally. The condition is that we can get out later, we can rescind later if things don't go our way, if we don't like it, and particularly if a Bill of Rights isn't added promptly. And James Madison wrote Alexander Hamilton back, and he said, no, no, no. A ratification is not conditional. A ratification is forever and in total. So from the words of one of our founding fathers, the father of the Constitution, there were attempts to rescind ratifications of the 14th Amendment, or 15th Amendment, the 19th Amendment, to some extent, you know, granting women's suffrage. None of those have ever been recognized. And under the law, a ratification cannot be rescinded. So it's a really poor argument. I can't predict how a court would rule, but I can tell you what the correct answer is, which is no, you can't rescind, you can't undo. Once you ratify legally, you are authorizing and adopting an act, and there are no takebacks. The other argument, and this is the one, if you've heard much about the ERA, this is probably the one you've heard about more, and maybe if you were involved in the ERA in the 70s, maybe this is one that's still in your mind, which is, wait, doesn't the ERA have a deadline? Wasn't there a 7-year deadline with the original 1972, ERA that was proposed by Congress? And then there were 3 years added on at the end to give an extension, but we still needed 3 more states. We only had 35 states that ratified, and the clock ran out in June of '82. And weren't there all those people in Springfield, Illinois, at our capital, all those ERA advocates literally chaining themselves to, parts of the chamber and having a protest where, some of them were practically starving. Yeah, that is all true. But legally, if you look at the amendment, you'll see there was no deadline within the text of the amendment for when the states ratify. The only time limit was, okay, once the amendment is fully ratified, it'll be 2 years until it goes into effect. The purported deadline was only in an internal resolution that Congress used to vote on the amendment. And those of you who work on legislative matters know that these legislatures generally work via resolutions. They'll propose something, and maybe even when you do business at the board of the League of Women Voters, you pass resolutions. The resolutions a group passes internally don't bind the other party unless they're actually in the amendment. And adding a time limit to the US Constitution, that's a huge change to the Constitution. There is no time limit on when states can ratify an amendment. And in fact, I told you earlier, states are the principals. They're the main driver in the amending process. To think that Congress on its own, outside of an amendment, could limit the time that states have is truly absurd. Well, does Congress on its own, outside of an amendment, have authority to limit the time that states have? Absolutely not. There's no anchor that is a plausible anchor, is a good, solid argument in the Constitution. There's nothing in the Constitution that grants that authority to Congress. And we talked about that when we were talking about Section 2 of the ERA, which gives Congress the ability to legislate, pass laws on the basis of the ERA. There's nothing in the Constitution that grants that authority. And you might even know that, I think it's the 10th Amendment, actually says, unless authority is spelled out in the Constitution for our national government, that everything else, all other powers, revert to the states and the individuals. I think what happened in the 70s is that women as a whole and ERA advocates were just really tired because most of them were unpaid and worn out advocating and going uphill. I mean, if you read some of the congressional testimony, it's really dispiriting and really insulting. But women were not in a power position then. What are they going to do? Go to Congress and say, you know what, your deadline is bogus. You never had the authority or the to set a deadline on the states in the first place. I don't think so. Also, at that time, all amendments had been, to date, all constitutional amendments had been ratified within 4 years. So the practice was that constitutional amendments would be ratified pretty quickly. So maybe within that time frame, it kind of seemed understandable. Our most recent official amendment is the 27th Amendment. It's kind of a stupid amendment, in my opinion, but it's about congressional pay. That amendment took over 200 years to ratify. We can talk about that a little bit, but that kind of changed some of the thinking on this. That amendment was added to our US Constitution in 1992. So that was part of the thinking when this three-state strategy came up of, why don't we just get 3 more states? If you read the Constitution's text and you look at its original history, there's no deadline. So again, if you want to go in the weeds, I'm more than happy to do that. What are the consequences of not opening this gift? Well, the general public is unaware that we have a new amendment. I will tell you, we do have a new amendment. Clearly, based on the US Constitution, the ERA is our 28th Amendment, but it hasn't been certified and published. Does that make it invalid? No, it doesn't. In fact, there's case law on that. It is, to me, it is part of the Constitution already, but there's a harm in not having the national government publish it. And the harm is that the public doesn't know the law. And in a democracy, for the public to not know what the law is it's anti-democratic. And if it hasn't been officially published, then the government's not going to enforce it. So the executive branches of both the national and state governments, they're going to say, well, we weren't put on notice that it's part of the Constitution, so it's not our job to patrol that or enforce it. And you're not going to have any laws passed on the basis of the ERA. And just like I told you, Congress needs an anchor in the Constitution for any of its actions, any of its powers. The same thing is that the ERA provides an anchor for laws to be passed that will help realize the intent of the ERA. And then really importantly, the courts are going to ignore it when they're deciding important cases. I think that the court ignored it last year in the Dobbs decision. I think that, so I told you that the ERA became part of the Constitution, not officially published, but part of the Constitution in January of 2020. And then we know from looking at the text of the ERA that there's that 2-year lag time before it's actually legally effective, right? So that is January of 2022. So technically, according to my interpretation and many other lawyers, the ERA became legally effective as of January of last year. That Dobbs decision came out in May of last year. And, maybe part of the catalyst was they knew that the ERA technically was part of the Constitution and they wanted to ignore it. I don't know, because, it wasn't officially recognized. We can talk about that as well. How will the gift be opened? Well, it's our national executive branch that's not doing its job. This is a bipartisan problem. The problem started in 2020 when Virginia became the 38th and final state needed to ratify the ERA. And the then National Archivist asked for legal advice from our US Department of Justice. This was during the Trump administration. And that administration wrote an opinion that many people within the legal community and advocates consider highly erroneous. It was under then Attorney General Bill Barr saying the ERA is dead, don't publish it, National Archivist. And it wasn't published. Well, we have the Biden administration now, and they said, well, we really support the ERA, but, so they still haven't acted. What the president has said, who's a 5-decade supporter of the ERA, is that he really wants Congress to weigh in on the ERA and still say that it is valid. There's some case law behind that, but I would argue it's sort of a weak argument. I would say the ERA is already done. And the Department of Justice has kind of argued a couple different things, including that, they think it is dead. And that's under the Biden administration, under Attorney General Merrick Garland, born and bred in Illinois. Our state, I've told you before, has been a leader. So in 2020, the 3 most recent states to ratify the ERA, I told you Illinois was the 37th, Virginia was the 38th, Nevada kind of kicked it off in 2017. So that was those 3 states. They joined together and they sued the archivist, and they sued under something called mandamus, which is like a command. So what they said in their filing is the national government is not doing its job, and we want you, we want you, judiciary, to command the executive branch to do its job. That's called a mandamus action. It's a pretty high bar to get the judicial branch to command the executive branch. The matter has to be clear and without dispute. Well, obviously there's a dispute because they're in court. I think it's clear. This court case that Illinois then led at the appellate level, the decision came out last year, and the federal appellate court, the DC circuit, said, I don't think it was a bad decision. They said, the bar for commanding the executive branch is really high, and the court felt that the litigants hadn't met that bar, but they also said, we understand your argument that the ERA is done. And as I say, it was through our Illinois Attorney General's office, Kwame Rule's office, that this action was taken. And the League of Women Voters, as well as the League of Women Voters of Illinois, were on amicus briefs. So Illinois is all along supporting the ERA. Another way to kind of get the gift opened is for Congress to act. I told you that President Biden says he wants to hear from Congress. And something very interesting has happened in Congress, which is that initially advocates were asking Congress to remove the deadline that Congress had set in 72 without any constitutional authority, I might add. But the thinking on the ERA has changed so much that the current resolutions in Congress, with strong support, incidentally, from the Congressional Black Caucus, that's where there's a lot of leadership on the ERA, that resolution now just affirms that the ERA is our 28th Amendment. So again, Congress actually has voted a couple times to basically say that we've been unable to get formal action in the Senate. Why? Because they've got that 60 vote threshold for the Senate to do just about anything. And we had 52 senators, including Collins and Murkowski, 2 Republicans, supporting the resolution in the Senate, but not enough to overcome the filibuster. But Congress, to a certain extent, has weighed in. We've had majorities in both houses, not concurrently and technically not a formal action by the Senate, but the Congress at this point also is saying, from a majority standpoint, the ERA is done. So that's pretty damn interesting. We could have state governments recognize the ERA. We did something interesting, and your president, Sandy, mentioned that we had a resolution that went through our Illinois legislature, and that resolution that passed last year essentially said, the ERA is done. National government, it's your job to publish it. Do your job. This is a states' rights issue. We ratified it. It clearly meets the requirements of the Constitution, so do your job. Other states passed identical resolutions or similar resolutions saying the same thing. So Illinois has, again, spoken up. And I should also mention in Congress, it was Senator Dick Durbin, who's the chair of the Judiciary, who tried to get the ERA moving a little bit more in the Senate and held the first, I think, hearing in decades on the ERA in the Senate last year. So Illinois. I think attorneys need to weigh in. I think attorneys need to be educated, and I think they need to weigh in. Maybe you've figured out from my talk that it's a technical legal issue. And I say to people, if it were a national plumbing issue, then I'd want to hear from plumbers. This is a technical legal issue. I think the answer is clear. I think attorneys need to weigh in. Something the league could do, and maybe we could try to get our national league once again to pass a resolution on the ERA, is to educate the public about the ERA. Let them know that this is done. And then finally, we could have a case that goes up to the Supreme Court where they read the Constitution based on originalism and textualism and states' rights and say the ERA is done. That's the correct answer. That's the rule of law answer. I don't know how they would rule. That's probably why Illinois chose not to appeal the decision at the appellate level, because it would have gone up to the Supreme Court. I want to stop talking now. I hope, I want to hear from you, but I hope that you did get the sense in some part from me that this is a gift and it's ready to be opened. And I thank you so much for giving me this chance to tell you what I know about the ERA. Thank you very much.
Thank you, Michelle. Are there any questions? You have to go to Q&A at the bottom of your screen and type them in, and then we'll have Michelle answer them. Are there any comments or questions? Any comments or questions? I don't see any.
I do see a thank you
yes.
from an attendee saying it was a very informative presentation, which it was. Thank you so much. I learned so much.
It's my pleasure to talk with you. I'm happy to talk about, anything you want to talk about. I mean, I love the ERA. I think it's really good. I have a son and a daughter. So when I had the great privilege to testify in 2018 to a committee of the Illinois House when they were considering ratification. I talked about my son and daughter. I think it's for both of them. It's a rule of fairness, and I think it should be in the law. Oh, thank you for the nice comments. I really appreciate it.
Another comment, absolutely wonderful presentation. Thank you. You know, I think for years we've all assumed that it's passed, it's there. And unfortunately, our government right now is a little dysfunctional. And hopefully the president will get behind this. Any other comments?
Oh, Paula Purdue. Oh, hi, Paula. That's nice. Paula has been a wonderful advocate. Paula, I hope you don't mind my mentioning your name, but she writes that some of us believe that that Biden just needs to ask the archivist to accept the ERA. Thank you, Paula. And Paula could probably give this presentation just as well. So nice to see you there.
No. Okay. Well, thank you so much, Michelle. We really appreciate it. Hopefully something will happen in the next year or two. Hopefully in a year. It would be
that would be great, Sandy. And it's just, I love talking about the ERA. In fact, my family is always excited when I'm talking to another group because I just go on and on. And I'm sorry this isn't more, I understand webinar is a great format, but more interactive and
right.
To not have to drive, although you probably have better weather than I do today. I wish I could see you in person because that's so much more fun. I know you're kind of a vibrant league and that, all of the leagues have been involved with the ERA. I do think maybe we can get, there's been great movement by our national league on the ERA. And I wonder if we can get some kind of, if we can get some kind of activity for the league. I think the league would be just a great group because, we're advocates for democracy. And I think we'd just be a great group to try to start educating the public. So I'm just going to plant that seed and happy to work with folks on that and so forth. Yeah. This is helpful. So I got one question, more info needed as to why it's important to get it published. Do we have a couple minutes where I can address that?
Yes, 5 minutes.
Yeah. Okay. I think the one issue everyone thinks about now is abortion. When we ratified the ERA, when Illinois ratified the ERA in 2018, advocates correctly said it's not about abortion because at that time we had law that provided women the right to control their reproduction. And the argument for Roe v. Wade was a different part of the Constitution. However, I do think that folks who care about reproductive rights are correct that the ERA would provide some greater freedoms than we're seeing in various states. And in fact, the more I have read through some court decisions, including Roe v. Wade, I would say that I think that the outcome of Roe v. Wade, not the reasoning, but the outcome is kind of an ERA outcome in that there's a balance. Any folks who know how Roe v. Wade came out, it was treating the different trimesters differently depending on the development of a fetus. And I think the ERA would be a balancing. It's a rule of fairness and balancing the rights of the pregnant individual and the potential of life. And I think it would come out something like Roe. And in fact, I've been told by folks who clerked at the Supreme Court when Roe was decided that they purposely didn't use an equal rights argument because the ERA was in the states. The ERA was sent out in 72, Roe was decided in 73. It was the thought on the part of justices of the Supreme Court that the ERA would be coming but they didn't want to kind of jump the gun and use an equal rights argument before the states could kind of weigh in on the ERA. But that's one thing, to some extent, I would say LGBTQ rights, where it's just blatant discrimination, where, folks can be refused to be treated as others are. Some of that's fine tuning. And again, it's a balancing under the law. Let me see, I see some Q&A. Okay, this is nice. How many states have passed resolutions? Oh, this is great. So Barbara asked, how many states have passed resolutions for the executive department to act? That's a great question. So Illinois did, I think Minnesota did. I'm going to guess on this, so I'm sorry, I can't answer that definitively. California passed a resolution. Hawaii's House passed a resolution very similar to ours. I think there were a couple others that passed resolutions as well. And I know that at least maybe a dozen legislatures were considering resolutions where the states were saying, national government, you have a duty, do your job. So I'm sorry to not be more definitive about that.
Thank you. We've got 1 minute left. We have time for one more question if anyone has one. I don't see anyone at this time. Michele, thank you. And thank all the members of the Guild that have attended this webinar. I'd like to remind you next month, we'll go back to the first Wednesday. It's Soup On. It's in person. And two of our members, Laura Davis and Mary Finley, will talk about how to interact and engage high school students to get them to register to vote. And that should be a very good one. Thank you again, Michele, and thank you everyone else. Thank you to the public library for hosting this. I can't speak more highly of the public library for doing this. Thank you very much. Have a good day, everyone.
Thank you.
Thanks, everyone. Thank you, Michele. Thank you, Sandy.
Thanks. Bye.